Hello students and welcome to the lecture. So students, as we know that we have started the salient features of the Indian Constitution, which is an important topic from the examination point of view. All right. And we have scheduled these, you can say the topics for the discussion under this series, like the introduction part, salient features of the Constitution, criticism of the Constitution, schedules of the Constitution at a glance, and the sources of the Constitution at a glance. All right. So these are the things which we have scheduled for the discussion. Out of this, basically, we have completed the introduction part. We have been discussing on the salient features of the Constitution for last few lectures, and the topics we are left with are the criticism of the Constitution, schedules of the Constitution at a glance, and the sources of a Constitution at a glance. Okay, so this is the picture we have created so far altogether. So we will start from where we had left in the previous lecture. Okay, so another salient features what we have here is the synthesis of the parliamentary sovereignty and the judicial supremacy. It means mixture. All right. So you could say basically in India we have the mixture of parliamentary sovereignty. It means that parliament having the power, but also we have granted the power to the judicial or the judiciary. All right. So what is the meaning of this? Let's understand. The doctrine of sovereignty of parliament is associated with the British Parliament, while the principle of judicial supremacy with that of the American Supreme Court. All right. So basically, you could say this system we had brought from here. All right. And this system basically we had brought from here. All right. So this is the picture. Got it? So just as the Indian parliamentary system differs from the British system, the scope of judicial review power of the Supreme Court India is narrower than that of what exists in US. Okay. So we could say that the British Parliament and the Indian Parliament, they both are different. But however, we had, you could say, borrowed the parliament system from the British. All right. And how the system is differ from the British, we had discussed this in the previous lectures already. All right. But here what we have seen, just like the parliament system of India differs from the British system, same thing is happen with the US constitution also. Like we have the judicial supremacy, or you can say judicial review power, which we had borrowed from the American constitution. But the scope of judicial review, what we have in India, is narrower than the scope of judicial review, what exists in US. All right. So that's why we had made a mixture. This is because the American Constitution provides for due process of law. Remember, the American Constitution provides for the due process of law against that of procedure established by law. All right. So you could say that, however, we had borrowed the judicial review power from the American Constitution. But in American Constitution, there is a due process of law. While in Indian Constitution, basically we have the procedure established by law. All right. They both are differ. All right. Article 21 is there to state this. So what is the, you can say, the meaning of due process of law and the process established by law? Let's understand that. So basically when we talk about the procedure established by law, then what is the procedure? The procedure is that no law should be framed which could deprive person from his life and personal liberty. All right. Whereas due process of law states that no law should deprive person from his life and personal liberty. Also, the law must be made in a manner of fair and just. Okay, so that is the thing. First is the process established by law, which we practice in India. So it means that the judicial review could be exercised on a matter that no law should be framed in India which could deprive any person from his life and the personal liberty. It means that the law must be made in accordance with the protection of the life and the personal liberty of the people. Whereas when we talk about the due process of law, then the judicial review could be exercised on a matter that no law should deprive person from his life and the personal liberty as same like this. Even there is a one point additional that also the law must be made in a manner of fair and just. It means that the law must be fair and just. Got it? So that is the picture. All right. So here you could see that this is the large scope. That is the narrow scope. Why? Because here only the law's personal liberty and life could be checked. But here the procedure in which the law was made means that fair and just process also be checked. All right. So in India, basically we practice procedure established by law, not due process of law, which is practiced in USA. All right. So that's why it is said that the scope of the judicial review in India, or you can say judicial supremacy in India, is narrower than the American Constitution. All right. Therefore, the framers of the Indian Constitution have preferred a proper synthesis between the British principle of parliamentary sovereignty. Why? Because there is a unwritten constitution, right? So the parliament gets the power to make modification. All right, like it is an unwritten constitution which gives the power to the parliament to make rules and regulations, okay, at some liberty. But when we talk about the USA, then we know that the USA having the written constitution, right? USA having the written constitution, which means that the USA having some restrictions, or you can say the American Parliament having some restrictions, and this gives the power to the judiciary so that they could review. All right. But in India, when we made both the systems, so basically we did mixture. Neither we give power to the parliamentary sovereignty nor with the judicial supremacy, but we took them at medium, right? The Supreme Court, on the one hand, can declare the parliamentary laws as unconstitutional through its power of judicial review. The Parliament, on the other hand, can amend the major portion of the Constitution through its constituent power. All right. Because both of them are getting the power from one single source, which is known as the Constitution. Whether it's a Supreme Court, whether it's a Parliament, they both are taking their powers from the Constitution. So, if the Supreme Court having the power that they could declare any law and any regulations made by the Parliament as unconstitutional by the virtue of judicial review. Similar thing happens with the Parliament. Like the Parliament could amend the major portion of the Constitution, all right, so that they could enjoy some liberty. But remember, the basic structure, the basic structure of Constitution could not be hurt. All right, keep this thing in your mind. The basic structure of the Constitution could not be hurt. All right. Thereafter, next feature we have is the integrated and independent judiciary. Integrated and independent judiciary. The Indian Constitution established a judicial system that is integrated as well as independent. All right. So, what is the meaning of this? Basically, you could say in India, we have the three levels of judiciary. First is Supreme Court. Second is High Court. Third is subordinate. All right. There is the three levels of judiciary: subordinate courts, and you can say lower court. All right. So this is the levels. All these levels are integrated with each other. Like the subordinate courts or the lower courts are integrated with the high courts. The high courts is integrated with the Supreme Court. All right. So you could say that if you have any issue, first you will reach the subordinate courts at the lower courts. All right. Then if you are not satisfied with the, you can say, the jurisdiction which you have got from them, then you could move to the high court. Even if you are not satisfied, then you could go to the Supreme Court and the decision of Supreme Court will be final. So that makes the judiciary as an integrated. Okay. All these layers are basically integrated to each other one by one or in the layer wise. All right. Independent means, let we will see. The Supreme Court stands at the top of the integrated judicial system in the country, like as we had seen. Okay. Thereafter, below it, there are high courts at state level. So remember, Supreme Court is at national level, high courts are at state level, and this is are at regional or district level. Okay. So this is the thing. Under a high court, there is a hierarchy of the Supreme Court, that is district courts, and the other lower courts. The single system of court enforces both the central laws as well as the state law. Unlike in USA, whether the federal laws are enforced by the federal judiciary and the state laws are enforced by the state judiciary. So basically, you could say that when we talk about the Indian judicial system, American judicial system, all right. So what is the difference between them? Basically, here is single court system. Here is federal courts and state courts. Okay, so that's the difference. So now let's understand them. Basically, in India and the USA, the one thing is common: the central government having its own powers, the state governments having their own powers. Similar thing in India also, like the central government having their own powers, the state governments having their own powers in, you can say, manner of making rules and the regulations. That is it. All right, but here is one big difference. Basically, in India, there is a single constitution. In USA, there is a federal constitution and the state constitution. All right. So you could say in India, basically, the single constitution empowers the central government and the state governments for exercising their powers by virtue of state list or the union list. But in America, basically, federal constitution is applicable on all over the country and every state having their own constitution also. All right. That's why they had the state courts which will enforce the state constitution, and they having the federal court which will enforce the federal constitution. But in India, we have the single constitution for both the center and the state. So that's why the single court system is prevailed in India. Got it? So that's why it is right here. Okay. Single system enforces both center laws as well as the state laws because central government gets power from the union list, state government get powers from the state list. All right. Unlike in USA, where the federal laws are enforced by the federal judiciary and the state laws are enforced by the state judiciary. Because federal constitution is different and the state constitution is different. All right. The Supreme Court is the federal court, highest court of appeal, the guarantor of the fundamental rights of the citizen and guardian of the constitution. So basically, as I have shown you the hierarchy of the courts, basically in India, the federal court or at the national level court is the Supreme Court, and it is the highest court of appeal. Beyond this, you could not file any case in any court. All right. This is the guarantor of fundamental rights. How? I will tell you in the upcoming lecture. All right. And guardian of the constitution. It means that the Supreme Court having the power of judicial review. Okay. So whatsoever the rules and regulations government makes, the Supreme Court could review them and could check out the constitutionality of that laws and the regulations. Hence, the Constitution has made various provisions to ensure its independence, security of tenure of the judges, fixed service condition of the judges, all the expenses of the Supreme Court charge on the Consulate Fund of India, prohibition or discussion on the conduct of judges in the legislature, ban on the practice after retirement, power to punish for its contempt vested in the Supreme Court, separation of judiciary from the executive, and so on. Okay, so basically that's make the independent judiciary. Okay, how? Let me tell you. First is that security of tenure of the judges is fixed. It means that once the judge has been appointed into the Supreme Court or in the court, then the Supreme Court judge could not be removed that easily. This required a impeachment process to remove any judge, and The provision could be, not could be, must. The provision must be passed by the special majority, which means two conditions: 50% of sitting and voting, and another one is 2 by third majority of sitting and voting. All right. So that gives the security or the secure tenure to the judges. Thereafter, the fixed service condition of the judges. It means that once the judge has been appointed, no changes could be made in his service condition. All right. So that he could do his work in a free manner. Thereafter, all the expenses of the Supreme Court charged on the Consolidated Fund of India. It means that expenses of the Supreme Court could not be stopped and could not be challenged. Thereafter, whatsoever the judges are doing in the Supreme Court, that could not be discussed in the legislature. All right. Thereafter, no Supreme Court judge is allowed to do practice after the retirement, so that the judges could be impartial and avoid partiality in greed of getting work after the retirement. All right. Second is power to punish for its contempt vested in the Supreme Court. Like you could say, the Supreme Court had order or passed some judgment to do some work. If the administration fails to do this, then the Supreme Court could punish the administration. This could ensure the supremacy of the court's judgment. Thereafter, separation of the judiciary from the executive. Okay? It means that the judiciary is fully independent from the executive or the government. Okay? So, you can say the fairness in conduct could be secured. All right. So, these are the provisions which made the court system in India as an integrated system and also the independent judiciary. Now, what we have the fundamental rights. Okay. So, fundamental rights are basically enshrined in the part third of the Indian Constitution. And basically, there are 6 fundamental rights to all the citizens. First is right to equality, in which Articles 14 to 18 comes. Right to freedom, Articles 19 to 22. Right against exploitations, Article 23 to 24. Right to freedom of religion, Article 25 to 28. Cultural and educational rights, Article 29 to 30. Right to constitutional remedies, Article 32. Okay, so these are the 6 constitutional rights which have been granted to every citizen of the country. Got it? Remember one thing here, that I will tell you about the fundamental rights in a detailed form in its lecture. I have the separate lecture on fundamental rights for you all. Till then, just remember this thing. And right to constitutional remedies, Article 32 basically stands for the Supreme Court. What does it mean? So basically, you could say, suppose, as I have told you, that there is a hierarchy. High Court, then comes the subordinate court. So as I have told you, if anything happens to you, then first you have to move to the High Court through subordinate courts. Then only you could move to the Supreme Court. There is no provision that you could directly reach the Supreme Court. except Article 32. Okay. Article 32 basically, in a simple manner, you can say, states that if anything wrong happen with someone in case of fundamental rights, or you can say anyone thinks that his or her fundamental rights have been deprived of, then the person could directly reach the Supreme Court. He is not required to pass from subordinate courts and go High Court, then the Supreme Court. So Article 32 empowers this. And basically, there is also one article which is known as Article 226. This stands for the High Court. It means that by virtue of Article 32, which is the fundamental rights, the person could directly reach the Supreme Court. And Article 226, which is the, you can say, constitutional right of people, if he or she thinks that his fundamental rights have been deprived of, then he or she could directly reach the High Court, not required to pass through the subordinate court. Okay, so remember this thing. The fundamental rights are meant for promoting the idea of political democracy. All right, it means that people should be living politically free. What does it mean? It means they operate as limitations on the tyranny of the executive and arbitrary laws of the legislature. Okay, so basically you could say this restricts arbitrary powers of the state, or you can say of the government. All right, that is known as the political democracy. Okay, it restricts the arbitrary powers of the state, but also there is some limitations on this. All right, like the tyranny of the executive and the arbitrary laws of the legislature. They are justicable in nature, that is, they are enforceable by courts for their violation. It means that if any violation happens in any fundamental rights, then the person could directly reach the Supreme Court by Article 32 and by Article 226 to the High Court. The aggrieved person can directly go to the Supreme Court, which can issue the writs of habeas corpus, mandamus, prohibition, certiorari, and quo warranto. About this, we will learn in the fundamental rights chapter. All right, so that the restoration of his right could be taken place. However, the fundamental rights are not absolute and subject to the reasonable restriction. Okay, so remember, basically in India, the fundamental rights are qualified in nature, but they are not absolute. What does it mean? It means that the rights are qualified. It means the rights are applicable, but they are not absolute, so that some reasonable restrictions could be happen on them. Okay. Further, they are not sacrosanct and can be curtailed or repealed by the Parliament through a Constitutional Amendment Act. But remember, it required the special majority to pass the provision. All right. They can also be suspended during the operations of the national emergency, except the right guarantees by Article 20 and 21. Okay. All the rights, all the fundamental rights could be suspended in the case of national emergency. We will see this in the upcoming lecture, but except two rights, which are Article 20 and 21. So students, basically in this lecture, we have covered till here. In the next lecture, we will continue from here. Till then, just revise all the facts and figures in the proper sense. All right. So we will start from here in the next lecture. Till then,